Hey folks, welcome to today's Law of Self-Defense coverage of the trial of Kyle Rittenhouse. I am, of course, attorney Andrew Branca for Law of Self-Defense. Tomorrow is the final day of argument in the trial of Kyle Rittenhouse, and by day's end, the jury will have begun their deliberations of whether the child who successfully fought off serial, murderous attacks by rioting adults is to be found guilty of crimes carrying sentences as severe as life in prison. I thought it might be helpful to step through the various criminal charges and legal defenses in summary fashion to refresh everybody's recollection of where things stand and what each side needs to get done. In the course of doing that, we'll first step through these issues as they were set before the jury in opening statements, basically a straight-up self-defense analysis for each charge, before considering the provocation issue that was injected into the case by the prosecution at the 11th hour. Then we can consider the implications of the state's ambush-style provocation gambit based on that 11th hour reveal of unicorn drone footage left on the prosecution's doorstep by the evidence fairy, and which has the potential to make all the self-defense argument so strongly in the defense's favor irrelevant. I'll also embed the video and transcript of Assistant DA Binger's opening statement so we can refresh our recollection of what he promised the jury on the first day of the trial he would prove to them beyond a reasonable doubt by the end. It's noteworthy that nowhere in Assistant DA Binger's opening statement was there any mention of Kyle provocatively pointing his rifle at others that night, and no claim that the attack by Joseph Rosenbaum was provoked by Kyle pointing his rifle or by any other specific acts on the part of Kyle. Indeed, Assistant DA Binger fails to use the term provoke or any variation of that term even a single time in his opening statement to the jury. That's 35 minutes of talking, well over 5,000 words. Provocation mentioned? Never. Finally, I'll share what I expect the last day of this trial to look like in terms of the sequence of events and their likely schedule, and how we'll be covering those live at legalinsurrection.com. Before we jump in, I would like to thank the sponsor of today's content, which is CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. Essentially, CCW Safe promises to pay its members legal expenses if the member is involved in a use of force event, and those expenses start big and get bigger fast, folks. If you've shot somebody in self-defense, they've died, and now you find yourself charged with manslaughter or murder, it's easy to burn through $200,000 before you even get to trial. So if you don't have that kind of money stuffed in a mattress, just in case you're compelled to defend yourself or your family, it can be helpful to have a partner standing behind you with the resources you need to fight that legal battle the way you want it fought, as if the rest of your life depends on it, because really, it does. Now, I've looked at all the companies that offer similar services. As you might imagine, I found that CCW Safe is by far the best fit for me. I'm personally a member. Whether they're the best fit for you is something only you can decide. But I do encourage you, I urge you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCWSafe. And if you do decide to become a member there, you can save 10% off your membership using the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10 at that URL, lawofselfdefense.com/CCWSafe. So let's take a first look at the criminal charges versus the legal defense of self-defense here in this trial. Although it's now clear that the state plans to base their narrative of guilt in this case on the legal doctrine of provocation, provocation was never mentioned as an issue in this trial until the sudden discovery of the unicorn drone footage. When Assistant DA Binger presented the state's theory of this case to the jury in his opening statement, he never so much as mentions provocation. So the trial started as a straight-up self-defense case with Kyle charged with 5 use-of-force offenses, all felonies, as well as a single misdemeanor unlawful gun possession charge. To each of the felony use-of-force charges, Kyle is raising the legal defense of self-defense, and these charges and the defense against them will be our focus here. As for the misdemeanor gun possession charge, properly understood, this charge is simply inapplicable to Kyle at all, and it ought to have been dismissed outright as a matter of law. I discussed that in my recent blog post, The Injustice of the Gun Charge Against Kyle Rittenhouse. You can find that at Legal Insurrection and elsewhere. Judge Schroeder failed to dismiss this charge for no very good reason that I can see, but it appears he has at least allowed for a jury instruction on this charge that should correctly lead a rational jury to an acquittal on this particular charge. I suppose we'll find out for sure about the jury instruction when we hear the instructions read to the jury on Monday morning. In any case, our focus here is on the 5 felony use of force charges, not the gun charge. To each of those 5 charges, the defense has, of course, raised the legal defense of self-defense. And when any defendant properly raises the issue of self-defense, as has been done here, it's not the burden of the defense to prove self-defense. Rather, the burden is on the state to disprove self-defense beyond a reasonable doubt. That doesn't mean, however, that the state has to disprove self-defense in its entirety. It merely means the state has to disprove any one of the 4 required elements of self-defense. Those elements of self-defense are innocence, that Kyle was not the initial physical aggressor in any of his use of force events; imminence, that the threat Kyle was defending himself against was in progress or immediately about to occur; proportionality, that when Kyle used deadly defensive force, he was facing a threat readily capable of causing him death or serious bodily injury; and reasonableness, that Kyle's perceptions, decisions, and actions in self-defense were both subjectively believed to be necessary and would also have been held, that subjective belief, by an objective person in the same circumstances. Now, there is a possible 5th element in self-defense cases, avoidance, involving a possible legal duty to retreat, but it does not apply in otherwise lawful cases of self-defense in any of the 39 stand your ground states, and that's a group which includes Wisconsin. Now, the defense knows that if the prosecution can disprove any one of those 4 elements beyond a reasonable doubt, their entire legal defense of justified self-defense collapses. So, to understand whether the state can overcome self-defense for any of the felony use of force charges brought against Kyle, we need to examine whether it appears to a reasonable degree of legal certainty that the state will be able to disprove any one of those 4 elements of self-defense beyond a reasonable doubt. Specifically, considering each charge individually, is it likely that the state can prove beyond a reasonable doubt that 1, Kyle was the initial physical aggressor, or 2, he was not defending against an imminent threat, or 3, he was not defending against a deadly force attack, or 4, that his subjective belief in the necessity to use force was objectively unreasonable. It's worth keeping in mind that with respect to the intentional crimes charged, the intentional homicide of Anthony Huber and the attempted intentional homicide of Gage Grosskreutz, the claim of self-defense essentially concedes the underlying conduct that would normally be a crime, the intentional shooting of the 2 men, but argues that the conduct was nevertheless justified as lawful self-defense. With respect to the recklessness charges, the endangerment of McGinnis, the endangerment of Jump Kick Man, and the reckless homicide of Joseph Rosenbaum, the claim of self-defense acts to neutralize the unjustified risk element required for conduct to be criminally reckless, arguing that as an act of lawful self-defense, whatever risk was created was a justified risk. Now, keep in mind, again, we're excluding the question of provocation for the moment. We'll address it separately. We're simply doing a straight-up self-defense analysis. So let's take a look at count 1 in the criminal complaint, which is the first-degree reckless homicide of Joseph Rosenbaum. So in the case of the shooting of Joseph Rosenbaum, charged as a reckless homicide, the same legal defense of reasonable self-defense acts to effectively align against the element of recklessness, calling for an unjustified creation of risk to others. Reasonable conduct with respect to a purported victim of that conduct cannot also be reckless conduct towards that purported victim. It's either reasonable or reckless, but it can't be both. So if it's reasonable self-defense, it's not reckless conduct. So does Kyle appear to be vulnerable to the state disproving any of the 4 elements of self-defense beyond a reasonable doubt in the reckless homicide of Joseph Rosenbaum? Meaning, does it seem likely to a reasonable degree of legal certainty that the state can prove beyond a reasonable doubt with respect to Rosenbaum that Kyle, 1, was the initial physical aggressor, or 2, that Kyle was not defending against an imminent attack, or 3, that Kyle was not defending against a deadly force attack, or 4, that Kyle's subjective perception of the need to do so was objectively unreasonable? And in my view, my professional opinion, the evidence suggests there is no reasonable ground to believe that the state can accomplish any of that. Rosenbaum was the apparent initial physical aggressor in chasing down a fleeing Kyle and fighting him for control of his rifle. That's the element of innocence. Rosenbaum's attack was actually underway, so we checked the box for imminence. Rosenbaum's aggressive fighting for control of Kyle's rifle was, if successful, a threat likely to end in Kyle's death. That meets the conditions for proportionality, and Kyle's subjective fears in this respect are certainly objectively reasonable, especially in light of Rosenbaum's earlier threats to kill Kyle. Conclusion: self-defense wins on count 1 with respect to Joseph Rosenbaum. What about count 2, the first-degree recklessly endangering safety of Richard McGinnis? This is probably the most slippery of the charges against Kyle in the context of the legal defense of self-defense. Unlike the other recklessly endangering charge involving Jump Kick Man, who was clearly attacking Kyle and against whom Kyle intentionally fired 2 missed rounds, there was no attack and defense with respect to McGinnis, meaning McGinnis was not attacking Kyle, and Kyle did not intentionally use force towards McGinnis. Indeed, Kyle's testimony is that he never even knew McGinnis was downrange of Rosenbaum when Kyle shot the attacker 4 times. The argument here by the state, which Judge Schroeder accepted for purposes of permitting this charge, is that even if Kyle's use of force against Rosenbaum was lawful with respect to Rosenbaum, it's theoretically possible that the specific manner in which he fired the shots might have created an unjustified or reckless risk to McGinnis. For example, the state might argue that if Kyle had used hollow point ammunition instead of full metal jacket ammunition, the risk of McGinnis being struck by an over-penetrating round would have been reduced. Or if Kyle had fired the rounds at an angle that was less aligned with the downrange position of McGinnis, the risk to McGinnis would have been less. If so, for any of that kind of thing, the increased risk not avoided might constitute unjustified risk sufficient to allow a finding of recklessness. The defense argument here will be that whether a risk is justified must be considered within the totality of the circumstances. Certainly, simply standing in the middle of the car source parking lot on a normal day and firing 4 .223 rounds down Sheridan Road would be an unjustified risk to others. Firing those same 4 rounds while a murderous aggressor is fighting for control of your weapon is another matter entirely. In the end, the jury will be asked to determine whether, in their judgment, the prosecution has proven beyond a reasonable doubt that the manner in which Kyle fired those 4 rounds created a risk that was unjustified under the circumstances. If not, the proper verdict on this charge would be an acquittal. Alternatively, given that even McGinnis himself was ambiguous about the danger caused to him by Kyle's shooting Rosenbaum, the jury may decide that the state has failed to prove beyond a reasonable doubt that Kyle endangered McGinnis at all, in which case the proper verdict on this charge would also be an acquittal. Finally, it's possible that the jury will conclude that the state has proven recklessness beyond a reasonable doubt, but failed to prove beyond a reasonable doubt that Kyle acted with utter disregard for human life. In that case, the proper verdict would be an acquittal on the charged crime of first-degree reckless endangerment, but a conviction on the lesser-included charge of second-degree recklessness. Conclusion: in my opinion, the state will fail to prove beyond a reasonable doubt that Kyle's conduct created a risk to McGinnis that was unjustified under the circumstances, and perhaps not even that Kyle's conduct created any risk to McGinnis at all. In either case, self-defense wins on count 2. What about count 3, the first-degree intentional homicide of Anthony Huber? Here, the question is, does Kyle appear to be vulnerable to the state disproving any of the 4 elements of self-defense beyond a reasonable doubt with respect to the intentional homicide of Anthony Huber? Meaning, does it seem likely to a reasonable degree of legal certainty that the state can prove beyond a reasonable doubt with respect to Huber that Kyle, 1, was the initial aggressor, or 2, that Kyle was not defending against an imminent attack, or 3, that Kyle was not defending against a deadly force attack, or 4, that Kyle's subjective perception of the need to do so was objectively unreasonable. And the evidence suggests there is no reasonable ground to believe that the state can accomplish any of that. Huber was the apparent initial physical aggressor in repeatedly striking Kyle with a skateboard to the head and neck and fighting Kyle for his rifle. That's the element of innocence. Huber's attack was actually underway, so the attack was imminent. Blows to the head with a skateboard and fighting for control of the rifle are both deadly force attacks, justifying deadly force defense. That's the element of proportionality. And Kyle's subjective perception of the need to do so was objectively reasonable. Conclusion: self-defense wins on count 3. What about count 4, the attempted first-degree intentional homicide of Gage Grosskreutz? Here, the legal analysis is essentially identical to that for Huber, the only charging difference between the 2 situations being that Huber was charged as a completed intentional homicide, whereas the shooting of Grosskreutz was charged as an attempted intentional homicide. In any case, the question here is, does Kyle appear to be vulnerable to the state disproving any of the 4 elements of self-defense beyond a reasonable doubt with respect to the attempted intentional homicide of Gage Grosskreutz? Meaning, does it seem likely to a reasonable degree of legal certainty that the state can prove beyond a reasonable doubt with respect to Grosskreutz, 1, that Kyle was the initial physical aggressor, or 2, that Kyle was not defending against an imminent attack, or 3, that Kyle was not defending against a deadly force attack, or 4, that Kyle's subjective perception of the need to do so was objectively unreasonable. The evidence suggests there's no reasonable ground to believe that the state can accomplish any of that. Huber was the apparent initial physical aggressor in aggressively running up on Kyle with a Glock pistol in his hand, as well as in reaching for control of Kyle's rifle. That's the element of innocence. His attack on Kyle was actually underway, so it was imminent. The Glock in his right hand made his attack deadly in nature and justifying a deadly force defense. That's proportionality. And Kyle's subjective perception of the need to do so was objectively reasonable. He didn't imagine the gun, for example. Conclusion, self-defense wins on count 4. And finally, we get to count 5, the last of the use of force felony charges. This is the first-degree recklessly endangering safety with respect to Jump Kick Man. So, although this is the same charge as was brought with respect to Richard McGinnis, the legal analysis here is much more straightforward. That's because in this instance, Jump Kick Man was in the process of attacking Kyle, and Kyle's use of force here towards Jump Kick Man was intentional in response to that attack. Because this is a charge based on recklessness, the question is whether the risk created by Kyle towards Jump Kick Man in firing 2 missed shots at him was unjustified under the circumstances. Well, if the shots would have been justified as straightforward self-defense had Kyle struck and killed Jump Kick Man, then they are justified in the context of mere reckless endangering as well. So we can just do a straightforward self-defense analysis as we would do had Kyle shot Jump Kick Man dead. The question then is, does Kyle appear to be vulnerable to the state disproving any of the 4 elements of self-defense beyond a reasonable doubt with respect to the shooting at Jump Kick Man? Meaning, does it seem likely to a reasonable degree of certainty that the state can prove beyond a reasonable doubt with respect to Jump Kick Man that 1, Kyle was the initial physical aggressor, or 2, that Kyle was not defending against an imminent attack, or 3, that Kyle was not defending against a deadly force attack, or 4, that Kyle's subjective perception of the need to do so was objectively unreasonable. And again, the evidence suggests there's no reasonable ground to believe the state can accomplish any of that. Jump Kick Man was the apparent initial physical aggressor in aggressively running up on Kyle and stomping him in the face with heavy work boots. That's the element of innocence. His attacks on Kyle was actually underway. That's the element of imminence. Striking someone in the face with work boots under your entire jumping body weight can clearly cause serious physical injury, meaning it's a deadly force attack, justifying a deadly force defense. That's proportionality. And Kyle's subjective perception of the need to do so was objectively reasonable. Conclusion, self-defense wins on count 5. So in short, my professional legal opinion to a reasonable degree of legal certainty is that the prosecution in this case has no likelihood of disproving self-defense beyond a reasonable doubt. Certainly with respect to Rosenbaum, count 1, Huber, count 3, Grosskreutz, count 4, or Jump Kick Man, count 5. The circumstances with respect to the reckless endangering of McGinnis, count 2, is more ambiguous and may be fertile ground for a compromise verdict by a split jury, but in my judgment, the state fails here as well. Now, let's move away from the straightforward self-defense analysis and consider this 11th hour attack by the prosecution using the doctrine of provocation. So if all that self-defense legal analysis sounds like bad news for the prosecution, that's because it is indeed very bad news for the prosecution, which is why the prosecution is now placing all its chips on the legal doctrine of provocation in a theory of the case it never so much as mentioned to the jury in its own opening statement at the start of this trial. The important thing to understand about this doctrine of provocation is that if the jury buys this argument, all the self-defense analysis we just did simply goes out the window, because a provoker has no privilege to claim self-defense at all. It's true that a provoker might regain that privilege by meeting certain conditions, but the state here argues that Kyle failed to meet those conditions. So if the jury is convinced that Kyle was a provoker who failed to regain self-defense, then there is no self-defense legal defense in this case. Specifically, the state began arguing for the first time late in the trial that Kyle Rittenhouse provoked Rosenbaum into a defense of others chase by pointing his rifle at an individual nearby, thereby losing self-defense through provocation. The state then argues that Kyle subsequently failed to meet the requirements to regain self-defense. As a result, the state argues Kyle is not privileged to claim self-defense as his justification. Further, the state argues that every other use of force event that follows, meaning every other count in the criminal complaint, can also be ultimately attributed to Kyle's purported initial provocation of pointing his rifle at an individual, and therefore he has no privilege to claim self-defense as his justification for any of the other intentional shootings or reckless endangerments either. If the jury buys this 11th hour provocation argument, then the entire self-defense chessboard is tipped over, and all the pieces so strongly positioned in favor of Kyle's legal defense of self-defense are just dumped on the floor. The only outcome possible then will be verdicts of guilty on every use of force count. You can understand then why the prosecution finds this provocation argument so attractive. Of course, this provocation argument is not without its weaknesses, the greatest being the ridiculously weak evidence in support of this theory of the case. The purported evidence of Kyle pointing his rifle at any individual consists of a late-found drone video and a Rorschach-like enlarged image taken from that video that could be anything or could be nothing. Indeed, adding the context of other circumstantial evidence, such as the admission of the state's imaging expert that his zoom process adds to the original image pixels of unpredictable color, and that right-handed Kyle would have had to suddenly decide to handle his rifle in a left-handed manner. By the way, no easy task with the way his sling was set up. It seems ludicrous that any reasonable juror could look at that video or the image from the video offered that it proved anything, whatever, beyond a reasonable doubt, much less that Kyle had pointed his rifle at an individual. As weak as their argument on provocation is, however, their argument without provocation is even weaker. So the state is running with the rather pathetic best argument they can bring to the table. And it just might work. I mean, I think it's unlikely that the state will be able to convince 12 jurors that this video and photo prove provocation beyond a reasonable doubt. Certainly not 12 rational, fair, and impartial jurors. But some jurors are neither rational, nor fair, nor impartial. And if any single juror is looking for a reason, any reason, to vote guilty, despite the pronounced weakness of the state's use of force charges in the context of self-defense, then this provocation argument may be just enough to tip the scales. Now, one convinced juror is not enough to render an actual verdict of guilt. That takes a unanimous decision of all 12 jurors. But one convinced juror is enough to hang the jury and result in a mistrial. And a mistrial on these grounds simply means that Assistant DA Binger is free to reboot the criminal prosecution of Kyle Rittenhouse all over again, bringing the same resources to bear a second time against a defendant whose resources will surely be substantially depleted for a second fight. And that would be, for all practical purposes, a win for the prosecution and a loss for Kyle Rittenhouse. Now, before I let you all go, it's perhaps worth noting how out of the blue this entire provocation argument now being raised by the state in the 11th hour is, especially given that it appears to be the state's only desperate hope for a conviction. On the first day of this trial, Tuesday, November 2nd, Assistant DA Binger made his opening statement to the jury in which he laid out for them the state's theory of the case and the claims he intended to prove to them beyond a reasonable doubt in his efforts to convince them to find Kyle Rittenhouse guilty of all the charges against him. Assistant DA Binger spoke for a full 35 minutes, presenting the state's view of the case to the jury. The transcript of his opening statement consists of 5,355 words. By the way, that's embedded in the text version of today's content. And among those 5,300 plus words and 35 minutes of talking, the number of times in that opening statement that Assistant DA Binger mentions the word provocation or any variant of provocation is 0. That's right, the very heart of the state's narrative of guilt to be presented to the jury tomorrow in their closing argument has literally 0 presence to be found in the state's own opening statement to the jury. The closest that Assistant DA Binger comes in his opening statement to anything like a suggestion of provocation by Kyle can be found when he's vaguely describing, without specificity or evidence, that Kyle might have somehow been responsible for Rosenbaum's pursuit.
You see him running. towards the 63rd car source. And behind him, running in the same direction, following him, is the defendant. As they get to the 63rd Street car source, there are some cars on the north side of that lot. Mr. Rosenbaum peels off behind those cars, and the defendant stops on the other side of those cars and turns towards Mr. Rosenbaum. Now, obviously, in an infrared video from a plane overhead, we don't know exactly what was going on at that very moment. We don't know what words were said. But what's clear is whatever that confrontation that was initiated by the defendant started, it caused Mr. Rosenbaum to come around the cars and start running after the defendant.
Note that Binger says nothing here about a pointed rifle. He says nothing about a nearby individual who might be the target of that pointed rifle. Indeed, he doesn't indicate any particular unlawful provocative act by Kyle at all. In fact, he explicitly tells the jury in his opening statement that at this critical moment, quote, "We don't know exactly what was going on," close quote. I don't think that's proof beyond a reasonable doubt. It's also worth noting that nowhere in the opening statement is there any claim of Kyle having pointed his rifle at Yellow Pants Man, as the state now claims in support of its desperate provocation argument, nor any mention of Kyle having engaged in provocative conduct by pointing his rifle at people throughout the night. Nothing substantive whatever about provocation in Assistant DA Binger's opening statement. I'm going to embed the entirety of that opening statement in video and transcript form in the text version of today's content. And now finally, to wrap up, just a quick word on key events to take place tomorrow when court comes into session and the rough schedule I anticipate those events to follow. Now, caution, the scheduling stuff I'm going to mention is just experience-based speculation on my part. I have no inside information. The morning, of course, will begin with Judge Bruce Schroeder reading the court-approved instructions to the jury. I've written with respect to these instructions in several prior posts, particularly Rittenhouse trial day 9, prosecution win on provocation jury instruction saves chance at conviction. You can find that at legalinsurrection.com. Reading the instructions to the jury might take perhaps an hour, maybe longer, given the many charges, including numerous lesser included offenses, as well as the multiple instructions on self-defense. After those are read, the state will then present its closing argument of guilt to the jury, almost certainly by Assistant DA Thomas Binger. Assuming the court comes into session before the instructions at 9, gives the instructions, then we hear the closing argument. I would expect the state to finish its closing argument right around noon. These are Central Time, U.S., of course. So the court would likely then take a break for lunch before we get into the closing of the defense. After lunch, the defense will follow with its own closing argument, most likely by defense attorney Mark Richards, although frankly, I think co-counsel Corey Chirafisi would likely be a better choice here. Their call to make. And after that, the state will have an opportunity to rebut the defense closing argument. Judge Schroeder has allocated 2.5 hours to each side. So we're looking at potentially 5 hours total of closing arguments. In any case, that would likely get us to mid-afternoon, at which point the jury will begin their deliberations. And then we wait and enter what we call verdict watch mode, in which I stay anxiously close to my computer for any breaking news of a verdict so that we're ready to share that news and our analysis of that news with all of you promptly. In the meantime, I'll be back on live coverage of all the trial proceedings tomorrow with live streaming of those proceedings and live commenting throughout the day over at legalinsurrection.com, as we've done for the entire trial to date. Okay, folks, that's all I have for you on this topic tonight. Remember, if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law so you're hard to convict. Until tomorrow morning, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.